In medieval England, a cartwheel, a boat, or even a bell could be treated as if it owed a debt for a human death. The idea sounds like folklore, but it belonged to a real part of English common law known as deodand. The word came from Latin, often understood as something to be given to God. In practice, it meant that when an object or animal was involved in a person's accidental death, that thing could be seized and valued. Not because anyone truly believed a wheel had thoughts, not because a boat had a soul, but because the law needed a way to answer a disturbing question. When someone died suddenly and no murderer could be punished, what should the community do with the object that had caused the death? A horse that threw a rider, a cart that crushed a passer-by, a mill wheel that turned at the wrong moment. These things could become deodands. A local jury might decide what the object was worth. That value could then be forfeited, often to the crown, though the older religious meaning suggested a gift devoted to God or charity. The strange part is how seriously this could be treated. The object was not put on trial in the modern sense. It did not speak, it did not defend itself. But the legal system still marked it as connected to the death. It was a symbolic answer to chaos. In a world of narrow roads, animals, open water, heavy wheels and dangerous tools, accidental death was never far away. Medieval law often blended punishment, payment, religion and ritual in ways that feel unfamiliar. Now deodand sat exactly in that blurred space. It turned an accident into a public matter. It gave a name to the thing involved. It allowed officials to assign a value, and it reminded everyone that a death, even without a criminal, could not simply vanish into silence. To modern ears, blaming a cartwheel sounds absurd. But to the people who lived with this law, the point may have been less about guilt and more about restoring order. Someone had died. Something had to be accounted for. And once the law began treating objects as answerable, it raised an even stranger question: who decided what an object's guilt was worth? A medieval jury could be asked to put a price on the object that had helped kill someone. That is where the strange law of deodand became more than a superstition. It became paperwork, procedure, local judgment. When a sudden death occurred in England, officials could investigate through the coroner's system. The coroner's role was not exactly like the modern office, but it did involve recording deaths, gathering local testimony, and protecting the financial interests of the Crown. If a person drowned beside a boat, fell from a horse, or was struck by a moving cart, the inquest might ask what thing had been the immediate cause. Then came the valuation. How much was the horse worth? What was the cart worth? Was the whole object responsible, or only the part that did the harm? Surviving records suggest that juries could be quite specific. A wheel might be valued separately from a cart. An animal might be named as the dangerous instrument. This was not modern accident law. There were no insurance companies studying liability, no safety regulators issuing reports, no mechanical experts reconstructing events with diagrams. Instead, the community interpreted the death through the tools it had: witnesses, custom, religion, and royal law. The system could be inconsistent. Similar deaths might produce different valuations. A poor person's dangerous object and a wealthy owner's valuable animal could create very different outcomes. And because the value often went to the Crown, rather than directly to the bereaved family, deodand was not the same as compensation in the modern sense. Still, it performed a function. It made accidental death visible to authority. It gave the community a ritual of judgment, and it placed a cost, however symbolic, on the thing that had crossed the line between ordinary life and disaster. This matters because old laws often look bizarre when we separate them from the world that made them. In medieval and early modern England, danger lived inside everyday objects. A horse was transport labour, wealth and risk. A cart was essential but heavy and hard to stop. A river was a route, a workplace, and a threat. Deodand did not solve those dangers, but it gave them a legal shape. And as England changed, that old shape began to look less like justice and more like a relic that could not survive the machine age. The old law of guilty objects struggled when the object was no longer a horse or a cart, but a railway train. By the 19th century, Britain was changing quickly. Machines were larger, transport was faster. Accidents could involve companies, passengers, workers, and complex systems of responsibility. Deodand had been built for a world where a local jury could point to a wheel, a boat or an animal, and attach a value to it. But industrial accidents made that older logic feel increasingly awkward. If a train crash caused deaths, what exactly was the Deodand, the engine, the carriage, the rails, the company's property? And what value should be placed on it? Some railway-related cases helped expose the problem. Large Deodand valuations could be imposed after accidents. But the process did not clearly answer the deeper question of responsibility. It punished property in a symbolic way, yet it did not create a modern system for investigating negligence or supporting victims' families. Historians often connect the decline of Deodand with this broader 19th century shift away from medieval forfeiture and toward newer ideas of civil liability regulation and public safety. In England and Wales, Deodands were abolished by law in 1846. That did not mean accidental death became simple. Far from it. The legal world still had to develop better ways to decide fault compensation and prevention. But the abolition marked the end of a very old idea that the object itself could be formally forfeited because it had been involved in a death. What survived was not the law, but the impulse behind it. When something goes terribly wrong, people still ask, what failed? The machine, the system, the owner, the rules, the inspection, the design. Modern law no longer treats a wheel as if it owes a sacred debt, but it still tries to trace harm through the objects and systems that shape daily life. That is why Deodand feels so strange and so revealing. It belongs to a world that seems distant from ours, filled with carts, coroners, juries, and religious language. Yet the question beneath it has never disappeared. When no one meant for a death to happen, how does a society decide what must answer for it? The law of Deodand is gone, but the need to make accidents accountable never really left.